Good afternoon, Mr. Best. Can you see and hear me okay?
Yes, Your Honor, I can hear you. Can you hear me?
I can, yes,
Okay.
sir. All right.
Great.
And Mr. Wash, are you there? I don't have a visual on you yet. Are you seeing the same thing I'm seeing, Mr. Best, kind of the gray screen?
Yes, Your Honor. Looks like a bunch of static.
Yes. That's a new one. I haven't seen that one yet.
You and me both.
My court reporter said maybe it's a background. I don't know. Let's see.
Can you hear me now, Judge?
Yes, sir. I can hear you, Mr. Wash, but I can't see you at all.
Okay.
Are you on a laptop or a computer or a cell phone?
A laptop?
Laptop. Do you know if your laptop has a webcam built into it?
I do not. I do not know.
Have you made an appearance on the laptop before on Zoom?
One time,
Okay.
but it didn't do too well then either, but I thought I was hooked up all right this time.
Well, you know, my settings show that you have video access. But for whatever reason, it's not working. But Mr. Best, do you have any problem moving forward? I'll take Mr. Wash's word for his whatever he wants it to be on this hearing.
No problems, Judge.
That's fine. Okay. All right, Mr. Wash, can you see Mr. Best and myself at all?
I can.
You can. Good. Okay. All right. It's a little unfair, but we'll let it slide this time.
All right.
All right. All right. This is cause number 20-0063. I believe this is Grimes versus Lewis. And I believe this is Mr. Best's motion to compel discovery and I believe motion for sanctions. Is that correct, Mr. Best?
Yes, Your Honor.
If you want to present those motions at this time, go ahead. Otherwise, if you and Mr. Wash have any kind of agreement, you can announce that too.
Okay, I guess I'll go briefly through the facts, Your Honor. Long story short is this is a personal injury case. I believe it was filed in February of last year. We propounded discovery, request for disclosure, interrogatories, request for production back in April. To date, we still do not have responses to any of this discovery. And it was back in November, I believe, I had filed a first motion to compel, or it was a first amended motion to compel. You signed an order back in November stating that plaintiff had to provide their responses within 10 days. So that I think would have fallen on November 22nd, give or take a day. Here we are in January and still do not have these responses. So we filed this motion as well as a motion for sanctions in the amount of $500 just to get this case to move forward. I will state for the record here that I don't care about the sanctions aspect of it so much. The money doesn't mean anything to me. Really, it's more of just a sense of getting this case going. We are now almost a year since suit has been filed and now 9 months since our discovery has been served, and I don't have anything. Mr. Wash did provide me with a 17-page PDF document from one medical provider about an hour and a half, 2 hours ago. He has assured me that I have some dash cam footage. This is stems from a car accident, Your Honor. Some dash cam footage that will basically be mailed to me, I think within the next day or so. But as far as interrogatories and the lengthy discovery responses that we sent, I with all due respect, I don't want to just rely on, we'll get it to you by the end of the week because it's been 9 months. So need some kind of assurances that this is going to get moved, because part of the concern with my honor, or Your Honor, is some of these records, what I fear is going to happen is I'm going to find out that this plaintiff has pre-existing conditions. I'm going to go try to subpoena some records, and then I'm going to find out that I just missed the cutoff, that maybe these records weren't being preserved because I didn't subpoena them fast enough. And as of right now, I don't have any medical providers that have been identified. So I'm just kind of waiting for this stuff to get provided to me so I can get going. Until then, this case has been at a standstill for the past 9 months.
All right, thank you, Mr. Best. Mr. Wash, would you like to respond?
Yes, Your Honor. Mr. Best has been more than courteous and understanding. I've had quite a few medical issues over the past year. In fact, I had 2 hospital stays in December of last year. But last year I had overall 7 hospitalizations. But I don't want to blame it on that. I just want to tell the court I have had some issues, and Mr. Best has been very courteous. My client has moved to Alabama, and I spoke with her yesterday, the day before yesterday, and she has all the paperwork on the discovery she needs to provide. I thought I would have it today, quite frankly, but I don't. So I just need to continue with her to see that she does provide the answers so I can provide them to Mr. Best.
Did your client give you any type of indication on when she may have that information to you so that you can provide the responses?
Well, my request, Judge, was that I have it today, yesterday, and I don't have it. She works long hours, 6 days a week. I'm afraid she doesn't understand how important this is, but I will again impress it upon her when I talk with her.
So you can't give the court any type of reasonable assurance as to when Mr. Best would get the information he's requested in discovery as to a date, a time?
Judge, I'm going to do that. How would a week from today be?
Well, I think I probably know what Mr. Best is thinking and what he would respond. And I think he's already kind of responded as to when he expected to have the information. I'm willing to let Mr. Best decide if that's something that he's agreeable to. However, well, go ahead, Mr. Best. Let me let you.
Sure. Thank you, Your Honor. Honestly, Mr. Wash can only give me what he has. I will say this, that, like I said, this discovery was sent back in April. And so April of 2020. So I understand some difficulties in talking with your client, especially as we get down to the date of this hearing. This motion was also filed 30 days ago. And so now to say that, well, I haven't been able to find my client, I don't know when I'm going to be able to get it to you. That's kind of the purpose of this hearing. Like I said, I don't care about the money. The sanctions part is okay. I just need some assurances that this case is going to get going. If he gets me these responses within a week, I guess that's okay. I guess just, I don't, quite frankly, I just don't know what else to do at this point. If these responses, if the week comes and goes and I still don't have them, and obviously if he gets it to me, let's say within a day or so, I'm not going to waste the court's time. But if we're, 2 or 3 weeks go by and I still don't have them, quite frankly, I don't know what else to do at that point. So, I know the court would be reluctant to grant any kind of death penalty sanctions or something, but now, like I said, we're going on 9 months and I still don't have responses here. Quite frankly, I'm just kind of at a loss of words as to what to do.
So, Mr. Wash, do you believe that if the court ordered for the discovery responses to be, and remind me, Mr. Best, you said that you had some requests for disclosures. Did you also send interrogatories?
Yes, Your Honor, interrogatories and requests for production.
Okay. And so, Mr. Wash, do you believe if I give you your client a week to get that all the information, all the responses to the request for disclosure, request for production, and the interrogatories, do you believe that you can have all of that to Mr. Best before 5 p.m. on January 18th, a week from today?
I do, Your Honor.
Okay, so what I'm going to do then is, Mr. Best, based on your position on the sanctions, I'm going to take the motion for sanctions under advisement until January 18th. If there's no response, if you have incomplete responses, then you'll notify the court and we'll get you another hearing, and then we'll come and we'll have this discussion again, and the court will re-entertain the motion for sanctions, and the court would obviously entertain any other motions you want to bring, Mr. Best, perhaps, striking pleadings or anything of that nature. If that's even as severe as that is, that may be what the court would have to do if there's no response to the discovery.
Understood, Your Honor.
Okay, all right, Mr. Walsh. So what I'm going to do, and Mr. Best, I'm going to ask you to e-file an order reflecting that order of the court that discovery is to be answered prior to January 18th by 5 p.m. close of business. And Mr. Walsh, I would just ask that you stress the importance of this to your client, and that she is on a schedule with the court, and that if she does not meet the schedule, she may find herself outside the court.
I will, Your Honor.
Okay. Is there anything else at this time that I need to take up, Mr. Best?
Not today, Your Honor.
Mr. Walsh, anything I can address for you?
Not at this time, Your Honor. Thank you.
All right. Well, Mr. Walsh, I appreciate you joining me today, along with you, Mr. Best, via Zoom. I look forward to hearing from one or both of you. And if you want to just give the court an email to my administrator as an update if the discovery is supplied, Mr. Best. Otherwise, you'll ask her for another setting, and we'll get you back in here on a Zoom hearing.
Okay. Thank you, Your Honor.
Thank you, gentlemen. Hope you have a good day. And Mr. Walsh, I hope you're feeling better at this time. And 7 hospitalizations in a year, that's way too much. So hope you're feeling okay and back on your feet.
I'm progressing. Thank you. Your
Good.
Honor.
That's good. All right. Thank you, gentlemen. You'll have a great day.
Thank you. You too.
Thank you.